Hello learners, let's understand the concept of contract law. Contract law. The Contract Act is one of the principal acts governing all the contractual relations not only in the business world but also from day-to-day life. It is one of the most important legislation ever drafted by the Britishers, and the principles enacted therein are nothing but the codification of the general principle governing the transactional relationship, because of which it has seen seldom amendments. Our day-to-day life is interspersed with many rights, duties, obligations through which we interact with the society. Non-exhaustive and not retrospective contract is probably the most familiar legal concept in our society because it's so central to the essence of our political, economic, and social life. The law relating to contract constitutes the most important branch of commercial law. This is governed by what? The Indian Contract Act of 1872. So let's understand what is the Indian Contract Act of 1872. The contract may be defined as a legally binding agreement, or, in the words of Sir Frederick Pollock, a promise or set of promises which the law will enforce. So it's a promise or a set of promises which the law will enforce. Now, Section 2H of the Indian Contract Act, that is 1872, defines contract as an agreement enforced by law. Thus, for formation of a contract, there must be an agreement, and the agreement should be enforceable by the law. The Indian Contract Act 1872 came into force on what? 1st September 1872. It provides a legal framework not only for trade and commercial activities in which contracts are involved, but also for social and familial contracts. All agreements are not enforceable by law, and therefore all agreements are not contracts. A contract binds both parties by words written or agreed by the parties. For example, an agreement to go to see a movie may be a mere agreement not enforceable by the law. Thus, all agreements are not contracts. Structure of the Indian Contract Act 1872. The originally excluded Act has 266 sections. Later, in 1832, Section 239 to Section 266 relating to partnership, and in the year 1830, Section 76 to Section 123 relating to Sales and Goods Act were repealed. Next comes what is proposal or an offer. Now, Section 2H of the Indian Contract Act, that is 1872, defines the term contract as an agreement enforceable by the law. A proposal or offer and its acceptance is the universally acknowledged process for making a contract, of which the former is the beginning point. Now, Section 2A defines a proposal as when a person signifies another his willingness to do or abstain from doing anything with the view of obtaining the assent of that other to such act. He is said to make what? A proposal. When one person expresses his will to another person to do or not to do something to take his approval is known as an offer. An offer must be definite, certain, and complete in all respects. It must be communicated to the party to whom it is made. Generally, the offer should be made with the intention to create what? A legal relationship. Promise in the case of social engagement is generally without an intention to create a legal relationship. For example, A's willingness to sell his radio set to B for rupees what? 500 if B accepts to purchase the same amount to a proposal by A for the sale of the radio set. Now, what are the essentials of a valid offer? While making a contract, it is essential that the offer should be communicated to the other party. A proposal is complete only when it is communicated. and this thing is discussed in what? Section 3. Now, a valid offer may be made either expressly or impliedly. An offer that is made by conduct is called an implied offer, whereas the one which is made by the words written or spoken is called an express offer, and this thing is discussed in section 9. The conduct of the part includes not only their acts but also their omissions. Now let's understand what are the various types of offers. So if I'm not mistaken, there are approximately 7 types of offers. So let's understand each of them one by one. Number 1 is express and implied offer. Now most offers are made explicitly or in words, that is spoken or written. Implied offers are ones that are made through means other than that of the explicit offer. Usually we look at the conduct of the parties to determine an implied offer. For example, when you board a public bus, it's not because the bus conductor has explicitly asked you to board the bus. Now the offer is implied in the fact that the bus plies on a particular route and is offering to transport people for a fare. If you board the bus, then you impliedly accept to pay the fare. Even returning the dog or providing any information in case of a general offer is a way of impliedly accepting the offer of the reward. For example, a person who boards a bus or who hires a taxi undertakes to pay the fare at his destination even though he makes no express promise to do so. Next comes the general offer. Now when the same is not made to any particular person but to the public at a large, it is known as a general offer. Now a general offer is one that is made to the public at large. Great. Anyone who acts upon the offer or performs what has been set out in the offer, that is the conditions, after seeing the offer will be said to have accepted the offer. If they are successful in fulfilling the condition of the reward, that is the offer, then they can claim the reward. For example, if Paris loses and she puts up ₹1,000 reward in return of any information, that is the consideration leading to discovery, then anyone who sees that offer is free to act upon it. Next comes your specific offer. Now a specific offer is one that is made to a specific person or a specific set of people. It is the most common type of offer. For example, when you offer a certain shopkeeper an amount of money in exchange of his goods, no other shopkeeper can accept your offer. Next comes the cross offer. So what exactly is the cross offer? When the offers made by two people to each other containing similar terms of bargain cross each other in the post, they are known as a cross offer. In these cross offers, even though both the parties intended the same bargain, there would arise no contract. For example, an offer to sell his watch to B for rupees what? 2,000 through a letter sent by the post. On the same day, B also wrote to A making an offer to purchase A's watch for rupees what? 2,000. Now when A or B sent their letters, they did not know about the offer which was being made by the other side. A contract could arise only if either A or B, after having the knowledge of the offer, has accepted the same. Next comes standing, open or continuing offer. So what exactly is this? Now an offer that is allowed to remain open for acceptance over a period of time is known as standing, open or continuing offer. For example, an offer to supply 1,000 bags of wheat from 1st January to 31st December in accordance with the others which may be placed from time to time is a standing offer. As and when the orders are placed, that amounts to acceptance of the offer to that extent. If the above stated illustration, if an order for the supply of say 100 bags of wheat is placed on what? On 15th of January, there is acceptance of the offer to that extent. So far as the remaining quantity is concerned, this offer can be revoked just like any other offer. Next comes communication of offer. Now, the communication of a proposal is complete when it comes to the knowledge of the person to whom it is made. Hence, the offer cannot be accepted unless and until it has been brought to the knowledge of the person to whom it is made. Let's understand this with the help of an example. Suppose Mr. X makes an offer that whosoever finds his lost dog will get rupees, say, 10,000 from him through a newspaper advertisement. Now, if Mr. Y reads the advertisement and finds his lost dog, he is entitled to get the said amount. But suppose Mr. Y did not read the advertisement. He found the dog moving astray on the road and submitted it to the police. Or suppose Mr. Y happens to be the neighbor of Mr. X and he finds the dog during his morning walk and takes it to the owner. He will not be entitled to the reward money, and this is what communication of offer is. The last one is promise. Now, when a person to whom the proposal is made signifies his assent, there the proposal is said to be what? Accepted. A proposal when accepted becomes what? A promise. Now, the person making the proposal is going to be the promisor, and the person who is accepting the proposal is what? Promisee. I hope you people have understood a little bit about the contract law. We will cover the next portion in further lectures. Till then, you can go to EduRev and attempt the shown test to understand this chapter in depth. You can unlock all the logged content, that is videos, documents and tests for CLAT with EduRev Infinity plan and ace your exams at less than 80 rupees per month. Thank you.